Hi, this is Mason Rothschild of the Mason Law Firm. So you're going for a nice walk one evening and you trip over an uneven portion of the sidewalk and you fall down and get injured. Can you sue the city or the county for your injuries? Well, that depends on the size of the unevenness of the sidewalk. Under the law in personal injury, there's something called the trivial defect defense, which says that a homeowner or government agency is not responsible for a defect that is so minor or insignificant that it merited a repairs to be done earlier, right? So in a case like this, the courts say that unless the raised portion of the sidewalk is at least 3/4 of an inch, you do not have a viable case against the county or the city. That is because the county or the city cannot be responsible for monitoring thousands of miles of sidewalk because it's impossible for them to do so. So how do you go against the trivial defect defense? The best thing to do is, if you're in a situation like that, is to measure the difference between the raised and the unraised portion of the sidewalk and take a close-up photograph of that measurement. In fact, we had that happen in a case a couple of years ago. Out here in Santa Clarita, we had a client who tripped and fell on a raised portion of the sidewalk. When we met him at the location of the incident, we took measurements and photographed the measurement showing that the elevation was about 1.5 inches. And it helped a lot because the following week, the city repaired that exact same spot where our client had tripped and fallen. If we had not preserved that evidence, we could not have had a case against the city. Best thing to do in a case like this is talk to an experienced personal injury attorney and get the evidence in hand and preserve it. My name is Mason Rothschild, and we meet our clients by accident.